Miville-Dechêne. Thank you, Madam Speaker. I rise to support in principle Bill S-251, presented by Senator Couture. Senator Couture's Bill S-251. On the face of it, this is a very simple, very short, very easy bill to support about the force used to discipline a child. Who among us here supports any form of child abuse? No one, of course. And how could anyone object to sending a clear message, even if only symbolic, of our determination to stop all forms of abuse, mistreatment, and trauma of Canadian children? Again, no one. Moreover, this issue touches most of us personally, whether as former children or as parents. Like many of my generation, I myself was physically disciplined as a child. I have a vivid memory of the very first spanking I received from my mother at the age of 7 or 8, when we lived in France. But what was worse was the physical discipline at school. At that time, in elementary school in Paris, it was a frequent tool used to subdue children. I remember classmates being spanked in front of everyone, and others being made to walk around the classroom by their ears by the teacher. It was the height of humiliation for those students. Back in Quebec in the 70s, attitudes had changed, at least at school. Unlike the wise and patient senator that I now am, I was a rebellious teenager. In fact, I remember my mother slapping me on the stairs after I had insulted her. Let's just say that it didn't improve our relationship. I would add that although I remember these physical punishments, they did not cause any lasting trauma. In fact, like many other children, I was affected much more by yelling, blaming, and talk in my family. Slaps hurt at the time, but words can hurt in the longer term. I doubt the state will ever legislate what a parent can and cannot say to their child. Bill S-251 therefore proposes to eliminate the exception in Section 43 of the Criminal Code, which allows a parent, among other things, and I quote, to use force to correct a child, provided that the force does not exceed what is reasonable under the circumstances. While I support the bill in principle, or the principle of the bill, rather, I note 3 objections or difficulties that warrant reflection. The first is a political question that recurs in many of our debates. How far can the government regulate private behavior? Of course, no one doubts that the government can criminalize violence against children, as it does for all people, especially the most vulnerable. When we talk about force not exceeding what is reasonable under the circumstances, however, we are also entering the realm of education, discipline, and discretion in the exercise of parental authority. Clearly, the state can and should protect children from violence, but it can and should also respect the judgment of parents.
It's important to remember that the exception provided at Section 43 is already quite narrow. Here are excerpts from a March 2021 letter from Justice Minister Lametti to I.D. Illingworth, the Federal Ombudsman for Victims of Crime. And I quote, "The issue of whether or not Section 43 should be repealed raises differing and strongly held views across Canada. As you are likely aware, assault is broadly defined in Canadian criminal law to include any non-consensual use of force against another person. This can also include non-consensual touching that does not involve physical harms or marks. Section 43 of the Criminal Code is a limited defense to criminal liability for parents, persons standing in the place of parents and teachers for the non-consensual application of reasonable force to a child. In 2004, the Supreme Court of Canada held that Section 43 is consistent with the Canadian Charter of Rights and Freedom and the United Nations Convention on the Rights of the Child. It also sets out guidelines that significantly narrow the application of the defense to reasonable corrective force that is transitory and trifling in nature. Moreover, the Supreme Court decision provided that teachers cannot use force for physical punishment under any circumstances. Il existe
There are many models and approaches to parenting. I do not believe that this great and complex human adventure can be reduced to an exact science, where there are definitive and universal answers applicable to all situations. For this reason, we must be careful not to target parenting approaches that we may not like, but that do not necessarily deserve to be criminalized. In the same vein, I note that there are not only differences between individuals and families, but also at times between cultures. The way children are raised, the role of authority, discipline, parenting approaches are often associated with our personal history or that of a culture. And cultures and family contexts also have an influence on the perception and impact of physical correction on children. Again, I reiterate that this is not about allowing abuse, mistreatment, or violence against children in any way. But neither should we find ourselves disproportionately targeting Canadians from minority cultures by removing the narrow exemption in Section 43 of the Criminal Code. Some parenting approaches may not be those that we personally would prefer. That does not necessarily mean that they are criminal.
Finally, I note something of a paradox. Many of the people who support this bill argue that we should not fear a wave of new prosecution of parents if we remove the exemption at Section 43. This is because, while removing the exemption would technically make it any non-consensual touching of children by their parents a criminal offense, everyone realizes this is an absurd situation. For this reason, proponents of the bill argue that if we remove the exemptions at Section 43, a new set of common law defenses and exemptions would apply, including an exception for minimal offenses, rules about necessity, implied consents, and other. So, are we really just removing one explicit, codified, narrowly interpreted exemption and replacing it with numerous, vague, and uncodified exemptions that would achieve the same purpose? In some ways, it could be argued that we are asked to make the criminal code less pragmatic and less realistic, and that, as a result, courts will have to develop new workarounds. In other words, the change we are contemplating may be more symbolic than substantive. All that being said, I recognize there is a global movement to remove these limited exemptions, even if it means developing new ones to replace them. As of 2022, 65 countries have banned corporal punishment. Even in France, Article 371-1 of the Civil Code was amended in 2019 to state that l'autorité
parental authority is exercised without physical or psychological violence.
Can make this commitment, perhaps we can as well. Society evolves, and it's normal that we adapt our legislation to reflect that change. Sometimes we update our laws to reflect the way we already live, and sometimes they reflect our aspirations. Just because things have always been one way doesn't mean that we must continue forever. I believe our laws play a role in setting the tone, and we must trust the institutions to behave reasonably in the circumstances. Merci.